case is stuck, you're not getting your visa interview, and you have no idea what the State Department or the embassy is doing with your case, or maybe USCIS is delaying your case. The big question is, can you sue an embassy or any other government agency to force them to give you a decision? If you want to know the answer, I'll see you on the other side of this video. Hello everybody, and welcome back to Immigration Channel. This is where we explain complex immigration matters in short, simple videos. We make immigration easy, and in this video, I'll tell you if you can sue a U.S. embassy or consulate or even an agency like USCIS if they significantly delay your case. We'll talk about what are the situations that you can actually sue the government and how does it actually work. If you're interested in this topic, make sure you watch this video all the way until the end. I'll go over some examples and we'll see if your case will fall in any of these categories. Before we do that, if you're here for the first time, you just saw my videos, you're just here on the channel, or maybe you're watching my videos every week, but you've not subscribed yet, please do me a favor. It helps the channel so much. And also, it will alert you when new videos come up. Please subscribe to my channel, give us a big like so YouTube will be able to show this video to more people just like you. And as always, if you need help with your immigration matter, there's a reason why you're researching these videos, you're watching. You might need help. You may know somebody that does. Send a text, 619-483-4549. We're here to help you. And if you don't want to text, you can go to www.immigrationasap.com. It's this very simple contact page. You put your information in there, you answer a couple of questions, and one of our team members will reach out and help you ASAP. So let's jump into the video right now. Nobody likes litigation. Nobody likes to go to court and sue the government or sue other people, but sometimes we have no choice. If the government is not taking action on your application, your visa case, your petition, you're left with no other options but to file what is called a mandamus lawsuit, which means forcing them to take action. That's all this lawsuit does. Forcing them to take action, giving you the decision that you deserve. Sometimes the government does not act when it comes to cases of naturalization, and for our cases, I-130 adjudication of family petitions, and in most common cases, finally giving you the decision on your visa appointment when you go to the interview or not even getting in an interview, and this is where we're dealing with the State Department. Sometimes they just don't give you an answer at all for years. Other cases may be delayed by FBI background checks. They'll tell you your case is now in admin processing, 221G cases, and they take years and years. Those are also cases sometimes we can sue to get you out of that stuck limbo. Now, in most cases, clients are not immediately going to sue the government. They're trying different things. In most cases, they just wait and wait and wait and inquire here and there and maybe use some kind of a congressional assistance. The bottom line is that everything that you do is not working. And so you have no other choice but to start thinking about litigation. What the mandamus lawsuit does is one simple thing. You go to the district court and we tell them, listen, this is what's going on. They are not taking action on our case, and there the federal court will compel the government to take action on your case. However, if your application is pending more than 18 months, if your application is pending between 18, 24 months, sometimes even 3 years, and or it's time sensitive because maybe your child is going to age out, maybe there's some kind of a medical issue. Those are situations where we have to analyze and determine if your case will qualify for a mandamus lawsuit. Successful with mandamus in F student visa petitions. In F student visa petitions, H-1B visa delays that went to admin processing, K visas, fiancé visas that were delayed either before or after the interview. We had a case where a guy went to the interview, everything was good, and he'd been waiting over 1.5 years to get a decision and no communication from the embassy. Those mandamus helped in L visa cases where a U.S. embassy will not release the case from admin processing. We've seen EB-1A cases that we didn't get decisions after filing an adjustment for years. As you can see, it can work for almost any visa application depending on the specific case. The same thing can work with USCIS. If you submit the case with USCIS, I-130 and 400, you paid the filing fees, you gave them the documents, and they haven't made a decision for years, you can also use the mandamus to try to resolve it. What is actually a reasonable time to process a visa petition or what is a reasonable time to process a visa petition or application? It is important to understand that because then you know if you have the chance to apply for mandamus. Remember guys, every case is different. And the context of the delay is really what is so important. For example, if there's a deadline to qualify for a visa, so let's say you have an H-2B petition. H-2B petition is subject to certain deadlines, Labor Department deadlines, and immigration deadlines. If your case is not adjudicated with the Labor Department on time, you will lose the opportunity to file your case with the second agency, in this case USCIS. If Labor Department delays your case for over a year and you lose the H-1B season, you definitely should file a mandamus to resolve it. Another example is the green card lottery. If you miss a deadline by a few months, it could be devastating for the future of your petition, and so mandamus has been very helpful in DV lottery cases where their adjudications are delayed. Now, there are other cases, for example, like if you look at EB-5 cases or maybe even some asylum cases where it's reasonable for USCIS to process them over 2 years because of the backlogs or because of others are also going through the same process, then they'll say, listen, this applicant is not different because all our petitions right now are taking that long because of certain backlogs or if there's no visa available to process it. So it's really important to look at it on a case-by-case basis. If you are from the Middle East, Pakistan, Iran, and other countries in the region, your applications for background checks might take longer than somebody who lives in Europe. In some cases, people who go into such backgrounds, they may end up being there for 18 months, sometimes even 20 months. And because a lot of applicants for that region go through the same time frame, it may not be considered to be unreasonable. But if it's a 4-year delay, that maybe yes, and maybe mandamus will be appropriate. So the bottom line, it's really important to look at your case, where you're from, the circumstances, and what embassy you're dealing with. Like I said, right now, a lot of cases with Pakistan, the Philippines, India, those delays of 2 years plus are not so unreasonable. When one stop are not that unreasonable. But when clients start getting into the 3-year mark, that's when we start looking at mandamus. But again, if you have some kind of an urgent reason to do that before, it can also work. Remember, there's nothing that is reasonable or irregular. Every case is a little bit different, and it's important to analyze your case based on the circumstance. The bottom line is that if we determine that your case qualifies for mandamus, it might be a good course of action. So let's talk about processing times. Even if immigration processing times say something like 30 or 60 months, which is unreasonable and ridiculous, even if their website says that, it doesn't mean that a lawsuit is not going to work. Because we can always argue to the court saying, this is not reasonable what they have on the website. And regular human beings should not be waiting 4 years to be reunited with their spouse. And those are the cases we're going to start analyzing and seeing whether a lawsuit is going to work or not. When will mandamus not be appropriate? Well, I'll give you an example. Let's say you went for your visa interview and now your case is being pulled for 221G admin processing. You're waiting in this processing for 3 months and now you want to file a mandamus. That's not going to work. 3 months of wait after 221G is not unreasonable in 2024. So you might have to wait a little bit longer. Regular inquiries, communicate with the embassy, find out what's happening, and maybe after a year, it will be reasonable. And again, it will depend on your case and where is the country of origins where the interview is taking place. So it is important to keep track of your case processing and speak with an attorney who specializes in those mandamus cases to understand whether you're ready to file that lawsuit. And the final question, could you reimburse your attorney fees? And the answer is yes. If your case goes to court and the judge rules in your favor, you could get filing fees. You could get the attorney fees back from the immigration. Again, it's not going to be possible in every case, but if you can prove their actions were not reasonable and justifiable, then you might be able to also request attorney fees. The conclusion is that if your case is stuck, you've been waiting for too long, you're desperate, there are certain things we can do, including sue an embassy or consulate, for example, like Islamabad, like the embassy in Mumbai, like the consulate in Ciudad Juarez. Those consulates and embassies were sued in the past and litigation was successful. So don't be afraid to consider it and speak to an attorney who can help you. Thanks for watching my videos, and I'll see you in the next one.